Because I carry a weapon for self-protection, and let's say I have an altercation with someone and I feel threatened, or that person threatens my life in some sort of way, and if I'm justified in using that force to protect myself, and I end up shooting that person to protect myself, and let's say that person dies, that is a justified homicide. It does not prove that I intentionally or knowingly took the life of that person because I was carrying a weapon to protect myself. Hey, good morning, everyone. Look, I want to drop in and talk about this Karmelo Anthony case. And there's been a lot of tension around this and a lot of emotionalism. And I want to remove that. I want to dispel some of the rumors and things that are out there. As a matter of fact, I don't even want to talk about the rumors. I want to talk about the facts and what we do know, okay? I want to talk about the law. First off, let me say this, a few qualifiers here. I used to live in McKinney, right off of El Dorado Parkway and Independence. And so those of you who are familiar with that area know exactly what I'm talking about. I lived right off of, right behind Heritage High School, and the area, the housing area where I lived at was the Heights of Westridge. So very, very familiar with that area. My kids ran track for Heritage High School. They played football. I'm very familiar with the whole scenery there, and very familiar with the people and the climate. I was also in law enforcement when I lived in McKinney. So just want to throw that out there and let you kind of know where I'm coming from. Now, what we do know is that Karmelo Anthony and Austin Metcalf got into some sort of altercation that day, and it resulted in this young man, Metcalf, being stabbed and killed. We also know that Karmelo Anthony admitted to stabbing him. So we do know that, all right? We do know that he has been charged with murder. Now, I am going to talk about the charges and why I think Karmelo Anthony has a good chance, at least a 50% chance of being acquitted. Let me tell you why. And I just want people to just kind of calm down for a second and let's look at the elements of the crime, because that is what's important. First off, I think they overcharged him. Murder is a very hard charge to prove. The Texas Penal Code, let's look at it, all right? I got it pulled up here. The Texas Penal Code for murder is 19.02. It says a person commits an offense if the person intentionally or knowingly causes the death of an individual. Drop down to the next section, or if they intend to cause serious bodily injury and commits an act clearly dangerous to human life that causes the death of an individual. Now, there's two words there that you should have really latched on to, and that is intentionally and knowingly. You're talking about the mental state of the person and what they were thinking. That is the hardest thing to prove. People say, well, he brought a knife. That proves it. No, it does not. Look, let me tell you, we're in the state of Texas. I carry a weapon. Because I carry a weapon for self-protection, and let's say I have an altercation with someone and I feel threatened, or that person threatens my life in some sort of way, and if I'm justified in using that force to protect myself, and I end up shooting that person to protect myself, and let's say that person dies, that is a justified homicide. It does not prove that I intentionally or knowingly took the life of that person because I was carrying a weapon to protect myself. You follow me? Okay, so having a knife at the school or having the knife on his person or about him does not mean or prove that he intentionally, knowingly stabbed this young man and took his life. That does not prove that. It does not rise to the level of the element of murder according to the penal code in the state of Texas. To make sure we're clear on that. Some say, well, he shouldn't have been there. Okay, well, if he was suspended, which we don't know if he was or not. That is not breaking the law. Now, it would have become a criminal law if he had been asked to leave by an authorized person who could represent the school district, a teacher, a coach, a principal, a school official. You get what I mean. If they had asked him to leave and he refused to leave, then they themselves would call the police. The police would then ask him to leave, and if he still refused to leave, then he would have been charged with criminal trespassing. That's how that works, folks. Okay? Austin Metcalf was not an authorized official. I don't care how many times people say he was asked to leave 15 times. I don't even know who was counting. I mean, was someone standing there taking count? That all sounds fishy to me. So let's just say he was asked repeatedly to leave the area or of their tent. Austin Metcalf or no other student owns the bleachers. They don't own that area. They're not authorized officials. Is it uncouth or is it uncustomary for another person from another team to go into another person's tent? Maybe. My kids knew people from all of the other schools in Frisco. Frisco's not that big, folks. The way Frisco is districted, or way the districts are set up, you may live 2 miles, literally. You may live 2 miles from another school, and your kids could live maybe a couple of streets over from you. You know, a lot of my kids had friends that went to Liberty High School, and we only lived a mile and a half, 2 miles apart. So you're going to see your friends, and a lot of these folks, these kids, they attend other activities outside of school together. So they know each other. So it's not weird that he would actually go to another tent because he knew someone. As a matter of fact, it's been testified that he was actually called over to the tent because a student that was under the tent from Memorial High School actually knew him and called him over. But all of those facts are still coming out in the reports, and we'll find out. But either way, it's not germane to the elements of the law. It has nothing to do with it. Okay, so I just want to clear that up. Now, what they probably should have charged him with, and they would have had a better opportunity to get a conviction, is manslaughter. Let me tell you why. Manslaughter is in Texas Penal Code 19.04. It says a person commits an offense if he recklessly causes the death of an individual. An offense under this section is a felony of the second degree, except that the offense is a felony of the first degree, which is murder, if it is shown on the trial of the offense that the defendant committed an offense under section 28.09, which section 28.09 deals with an attack on a critical infrastructure facility here in Texas, and it's related to terrorism. So we know that that did not apply. So they probably should have charged him. If they were going to charge him anyway, should have charged him with manslaughter. So I think they gambled on the murder charge. Now, let's talk about the knife, because people are saying, well, he should not have had a knife on school grounds and he broke the law. Well, actually, no, he didn't. He broke a school policy. Why? Because in Texas Penal Code 46.03, it states it is illegal to possess a location restricted knife, defined as a knife with a blade over 5.5 or 5.5 inches in length on school premises, including buildings, grounds, school-sponsored events, which would have been the track meet, and school transportation vehicles, school buses, vans, etc. So the school could have implemented a policy to say no knives, period. Whether it's 5 inches long, 5.5 inches long, or 10 inches long, doesn't matter. The school could have implemented a policy, in which I'm probably sure that they did. And if I remember correctly, I believe all weapons were prohibited on school grounds when my kids went there. So that is a school policy, but not against the law in the state of Texas, unless that blade exceeded 5.5 inches long. So let's say the knife was over 5.5 inches long, and it violated state law. It's a Class C misdemeanor. which is the lowest charge that you could get in the state of Texas. It's a $500 fine, and you might spend a night in jail. So to everyone who's inflating this whole notion that he had a knife on him and that this was some felony, it was not. So I'm painting a picture here to give you some context according to the law, which is factual, not how we feel about it or not how revved up and charged we are over this incident. It's terrible. And Karmelo Anthony, I think, made some bad decisions. I think he could have made some different decisions that day. But at the same time, I do want people to understand that it gives no one the right to grab you or to assault you, because we also can't forget that. And I do believe that had this been the other way around, there would be a different outcome. Now, some would say, oh, you're being racist or you're race baiting. No, I'm stating precedent here, because we have seen it the other way around. Now, Kyle Rittenhouse, we saw this young man go to a protest, and he actually brought a AR-15 and carried it out in the open. Now, he was found not guilty and acquitted of murdering at least one person and injuring another. He said he feared for his life. Now, if you use the same logic that we're trying to apply to Karmelo Anthony, then because Kyle Rittenhouse brought the weapon to protect himself, did he intentionally, knowingly kill that person? I want you to pause and I want you to think about that. I want you to think about the Trayvon Martin case and Zimmerman. Zimmerman went after and pursued or walked after, however you want to term it, walked after Trayvon Martin when the operator, the 911 operator, told him not to. That was clear. That was in the audio. We all heard it. And at some point, there was a confrontation. Trayvon Martin defended himself, or they got into an altercation. Some may say he attacked him. But either way, Trayvon Martin ended up being shot and killed by Zimmerman. Zimmerman had a weapon on him. He walked after Trayvon Martin. He continued to follow him even after the 911 operator told him not to. But Zimmerman said that he feared for his life, and he was found not guilty in a court of law. So my question is, if these two people or two young men feared for their life and stood their ground and used deadly force to protect themselves, why then is it different in this case? So that's the precedent that I'm talking about and what I'm referring to. So I want us to continue to follow this case. I will continue to follow it for sure. I want us to block out the noise. Look at the facts. What does the law say? Because everyone's going to say all of these other things and make all these other excuses, but it has absolutely nothing to do with what the law says. And I do believe that if the jury listens to all the facts, and they are the only ones who are getting the facts. I will tell you this, from what I'm hearing so far, there are a lot of inconsistencies, even from the witnesses. And the jury also is taking note of that. This is going to be very interesting, folks. And no matter what the outcome is, we all have to make sure that we maintain our cool, not do anything crazy. I will not be shocked if he is found guilty, because that is the precedent that we're dealing with here in this country. I will be shocked if he is found not guilty, because I think based on the merits of the case, based on the elements of the law, you have to be able to prove that he intentionally and knowingly took this young man's life with the intent to kill him. You have to be able to prove that, and that is a very high bar. I think the prosecution overreached on this. Should have been manslaughter. But anyway, that's my thoughts. You all stay encouraged. I want you to stay locked in, stay focused. Don't be distracted by the noise. All right, y'all have a good one. Take care. I'm gonna push the button and get out of here, y'all.